Hello, inventors and entrepreneurs. My name is Courtney Laskowicz. I'm the managing director here at Inventors Groups of America, and welcome today for our very special Inventors Online. Thank you, everyone, so much for joining us today, and it's going to be quite humbling, I will have to say, for today. Of course, those you are new here, go ahead and flash your hands in front of the screen. We'd love to see if any of newbies are here. Excellent. Very cool. Well, welcome to those of you who are new. IGA was founded in 2017 by Stephen Key and Andrew Krauss to teach individuals how to best commercialize their product ideas, as well as strengthen and support inventor groups throughout the nation. We have a directory of local and regional inventor groups on our website whom we meet with every month. And if you are located near one, we highly encourage you to join. Now, we would love to hear your name and what state or country you are from. So go on over right now, open up that chat box on the bottom right-hand corner, and please let us know. Of course, please do not disclose anything that is confidential and is not already publicly available. Our meeting is being recorded and will be harnessed on our website and YouTube channel soon after. Now, today, in the second half of this meeting, we will be interviewing Director Vidal, and the director of the United States Patent and Trademark Office. Maddie, our marketing director at IGA, has been writing with her dad, Steve, on licensing, entrepreneurship, and intellectual property strategy for the past 15 years. She will go ahead and start us off with the meeting and discussion and questions surrounding intellectual property. Maddie, go for it.
Hi, IGA. It's a pleasure to be here with you today. I've been working behind the scenes this year to book speakers and make this community as successful as it can be. And first, I want to say a big thank you to everyone who filled out a survey response to the questions we asked about working with the USPTO. It was extremely interesting reading all of your responses, and there really was a huge range. There were people who had almost an easy, straightforward experience with the USPTO. There were others of you who found your experience to be frustrating and confusing. Particularly helpful were all of the feedback that you provided about how to improve your experience working with the USPTO. We have shared your responses with the director, and we'll be touching on those if we have enough time at the end of the meeting. What I'd like to do for the first few minutes here before we have the director joining us around 1:30 is ask Steve, Courtney, and Andrew a little bit about their experiences with IP. So much of IP is often written from a legal perspective. There's a lot of confusing language. It's not really being talked about as a layperson. So if you'll bear with me, Steve, when did patents come on your radar as an independent product developer?
Well, that's actually a great question, because I was creating novelty gift items and licensing those items to companies and didn't even think about intellectual property. It never crossed my mind. I never thought a company would take an idea. I never thought I should even protect an idea. In fact, I didn't even know the tools. I had heard this word patent, and it seemed way out of reach for me. Mm-hmm. But I finally came up with a big idea. And when I sent it to a very large pharmaceutical company, the first thing out of their mouth was, when they saw my new innovation, do you have a patent on that? And that's when I panicked. And I think what everybody does, I called the patent attorney right away and said, hey, what do I do now? I was fearful. And I thought, in fact, I didn't know what to think. I put all my all my worries on the patent attorney, that he was going to guide me through this process. He was going to be my savior. He was going to be that person that was going to make this happen for me.
Was he your therapist too, Stephen?
He was everything. and what I realized, looking back, I think all of us at one time or another are just a little overwhelmed by all of it, and we don't know what it means, and we're confused, and we know it's complicated, and we know it's expensive, and we think people are going to steal our ideas, and we think that we have to have a patent, and the USPTO is trying to keep us from that patent. That's what I kept on thinking. They don't want me to have my patent. Mm-hmm. And what I realized, filing over 20 patents and receiving over 20 patents. They're in the business of granting patents. That's what they do. So they're really there to help you, not to hurt you.
Mm-hmm. Courtney, what has your experience been like with IP? I think that you filed a couple provisional patent applications. I'd love to hear a little bit about what that experience was like.
Yeah, absolutely. When I learned that I wanted to license an idea, I slowly understood, the process, the 10 steps. I thought PPAs were the first thing you did. In fact, I thought it was a full-blown utility. You immediately go ahead and you've got an idea, you patent it. That is the second thing you do. And I would say Steve hit it pretty spot on that I was very fearful. In fact, I was quite terrified that this would be a very long, painful, grueling process of, okay, I've got this concept, it's on my piece of paper here, and now I contact the USPTO and say, hey, I want a patent. Can you make me one? What is happening here? How do we go about this? A lot of fear, especially in just the lack of knowledge, not being aware of the realities of when you should, was a little scary, I would say. Once I got more education, went to the USPTO's website and then chose to put my education first and just look around, and they're actually not this scary monster. It's just oh, they're here to help. Oh, they care. Look at all these inventor resources. It was shocking to me. I don't know where that fear was embedded initially. I think a lot of us have that. And so when I eventually went through the USPTO's website, took hold of their resources, and then when it was time to actually file a PPA, I felt way more prepared, far less scared. There is a process. You can go through that process. You can contact people to help you write your PPA, the line drawings, all of that. And then when you actually go through the USPTO, the process is actually pretty simple to be able to upload your documents and file it. And so I'm confident now that I can do it pretty easily. I've filed a couple of PPAs, and it's much easier than I thought. Let's just say there's a lot of, just as all of us as inventors have these mental barriers that we put up, and usually they're quite different than the reality of the situation. And so now I enjoy it. It's okay. I'm good to go with it. That fear is no longer there, but it was far easier than I thought it was originally.
Sure. Andrew, I believe that you've been helping inventors with their intellectual property before provisional patent applications were even an option.
Yeah.
You've coached and mentored so many Invent Rights students to do that. Do you have any tips and advice for our audience about creating a better PPA?
Yeah, it's interesting that both Stephen and Courtney used the word fear. I think a big part of my role as co-founder for Invent Right, where we coach and mentor inventors to license their products, is to help people overcome their fear. And just as a member of the inventor community, and one of the ways I do that is to explain to them that provisional patents are something anybody can do. I have students that don't have a GED that are able to do it. Now, one of the reasons why I think people think they can't do it is they do a basic patent search. Maybe they don't really know what they're doing, and they see the wording, right? And they're like, what the heck is this? This is some sort of foreign language. I can't do that. And I make it very clear to them, you don't have to. And the great tool that the Patent Office has given us is the provisional patent application, which lets the layman, anybody, write a provisional patent application in common English. So not only is it something that any of you can do, but it's also the wisest path to take that year that the Patent Office gives you. And if you're licensing it, fish off the pier and see if there's interest first, because you might make some changes. Or if you're venturing it and going to sell it yourself, you still want to utilize the year that the Patent Office gives you. So I think a big thing that I do constantly, pretty much every day, is help people overcome their fear that they can't do that and show them that they can. I've got some other tips too, if you want me to ramble more about that. But
have you ever called the USPTO yourself? I keep hearing that they have amazing customer service, and even sending some emails back and forth, people have responded. And I think we all know how difficult it is to get an email response from someone you don't know online. So that's been my experience.
People are blown away. You have to realize the Patent Office, they are a government agency, but they're funded with your patent dollars, if you will. And so they just seem a little bit more customer oriented. They're thinking of you as customers. You know, that's what I've found. And so I tell people, even if you don't need it now, just call the 800 number and ask for help with something, and you'll be blown away as how helpful they are. I talked to this one woman, she was not tech savvy at all. That's what she said about herself. She's like, Andrew, I followed your advice. I couldn't believe it. The guy stayed on the line with me for 2.5 hours. She doesn't have a problem with her PDF. Sometimes people have a problem with their PDF and uploading and getting that PPA in. And that's an extreme example, of course. I wouldn't expect them to stay on 2.5 hours, but you call that 800 number, you say you're an independent inventor, and I've seen it. They are very, very helpful, and it doesn't cost you anything to do that. So I encourage people to do that. The other tip that I'll give, go ahead, Stephen.
Well, you know what's really interesting, and I'm glad everybody's joining us today. And I've always asked this question. The USPTO has been very helpful, like Andrew said, 800 number. But this last year, they really stepped it up. And I don't know how many people get their newsletter, and we're going to talk a little bit about that a little bit later when the new director comes on. But they have so many classes now, and everything's gone online. They revamped their website. They've made it so easy for us to get involved in that world. They've really stepped it up, and I'm a little confused by it. And I don't get it, because even though patents are important to all of us that are listening today, we're a small part of their world. You know, if you think about it, only 5% of us independent inventors file patents, but all their energy goes to helping us. And that's the question I'm going to ask the new director. Why do you bother with us when we're only 5% of that revenue that comes in? And it's going to be interesting to see what she has to say, because they make such an effort to help each and every one of us. So that's one of the other questions. The other thing too, you guys, I want to thank everybody for sending in your experience at the USPTO. Madeleine mentioned a little bit about it, but when I read it, I went through each and every one. And what I realized, some of those same concerns, you reached out to me, I have the same concerns too. You know, like, why does it take so long for a patent to issue? Sometimes they issue fast, but sometimes they seem to go on forever. And I don't know what's going on. Also, another big question that came along was, hey, when can I get notified they're actually even looking at it? It goes into this black hole, and who knows when they're ever going to get back to me. I'm like, come on, this is killing me. I need an answer here.
What was the suggestion there, Stephen? It'd be nice to know where you are in queue instead of.
Yeah, like, where am I in the process? How long is it going to take? I thought that was a really interesting question. But here's the other one. I know a lot of us are doing Google searching for patents, because the USPTO patent searching, although they've got a new searching tool, it's a little clunky. I mean, even the experts at this are telling us, do Google patents first, searching first at Google patents, and then do a deeper dive over at the USPTO. So my question is, you know, we're going to ask her later, what are you guys doing about that? I mean, you're the USPTO. It should be the easiest place to go to do that patent searching. So I think having that input from each and every one of you, and having you tell us, and we can tell the director what your concerns are, is what this webinar is all about today. So I cannot thank every one of you for sending those in to me. It was really important for us to have an open communication with the new director.
Sometimes you guys have concerns about stuff that we're like, well, that's not really a problem, because Steve and I have been educating inventors for the last 22 years and beyond. Like somebody said, oh, why does it take so long to get a patent? And Stephen and I's response, well, if you're licensing, our students license stuff all day long where it's patent pending. So this perception that you can't license something until it's issued. So there's a lot of ways to kind of break down some concerns. You have a concern, and it's like, well, why is that a concern? And so there's things that I think that need to be fixed, and then there's things that you think need to be fixed, but when you look at it from a different perspective, maybe it's not that big of a problem. You know what I mean? No,
the other thing too, Andrew, that really stood out to me was someone said, I wish I knew more about a provisional patent application. And I wish they would promote it more. And because I just spent money on a non-provisional, it cost me a lot of money. I didn't know about the PPA.
What's remarkable is the PPA, to my knowledge, is something that only exists with the United States Patent and Trademark Office. So it's really a huge advantage to anyone who wants to file here in the US, and quite amazing. Something I'm hoping you could touch on a little bit, Stephen, is I think people are very aware that what a patent is supposed to do is protect you. It means you have an exclusive right to make, sell, or license your invention. It is supposed to prevent others from being able to do that. And I know that we look at patents a little bit differently in the value that they can have. So I'm wondering if you could touch a little bit on what you think about when you're writing or drafting a patent application. What are you going to do with that? Who are you going to share it with? Who are you writing it for?
Yeah, I think that, and that was a lot of input from people saying, I'm afraid that people are going to steal my idea. I'm not quite sure about the patent system. I hear it's broken. I heard that too. And what I'm here to tell everybody, having a patent gives you the right to sue a company that's infringing. It just gives you the right to, right? So, but I don't look at that as a positive to sue somebody, because I've done that before. And I think it's complicated, it's expensive, and sometimes I don't think it's warranted. I think today a patent allows you, number one, to know what you're talking about. Gives you credibility. I think number two, if you're a startup, it allows you to raise money. In fact, it's the number one tool that startups use to raise those dollars they desperately need to be successful. If I'm an inventor and I want to license my ideas, it gives those licensees the option. If I file a PPA, it gives them the option to file a non-provisional application to go for a patent if they want to help pay for it, if they want to help put their muscle behind it to protect it. So it has a lot of value. So, but you have to be somewhat realistic. And this is the question we're going to ask the new director, right? If I have a patent and if I can't defend it, is it really worth anything? I mean, that's a fair question, right? Now, you know what else is kind of interesting? And Andrew and I have said this many times, the reason why we like product licensing so much is that the best protection is licensing it to a big company that can protect it. Holy smokes, there it is, you guys. And you've seen that with a couple situations that are currently happened today. Very popular toy inventor licensed it to a really big toy company, and they were able to protect that because they had licensed it to a company that had deep pockets and was willing to fight. So Madeleine, I do believe that we just have to shift our thinking a little bit about it and be realistic about it. But I do think it has great value today.
Also, one of the things that Steve and I talk about quite frequently, and Maddie's helped write about too, is that patents aren't the only form of protection. When you're licensing, you license to this huge company, right? And they have great distribution. They can crush the competition with their distribution, you know, the knockoffs, what have you. So don't undervalue the licensing to a large company and the distribution they have. It's not all about patents. Even large companies, if a product isn't making them tons of money, they're not going to run around suing everybody. They know how expensive that is. But the distribution is huge protection, guys, when you're licensing. It really is.
You know what I also like? When I've filed a well-written provisional patent application and I'm working with a really big company, right? A billion-dollar company. And if I've done a good job and they look at it, it gives them confidence to work with me, right? It shows that I've done my homework, that I've invested my time, that I did the first step to protect my invention, my innovation. So I do think it has a lot of value. So you just have to be realistic about it, and you have to learn how to file them right too, you guys, and file good intellectual property. I know a lot of patent attorneys, even Kevin Prince would probably admit, you have to look at it from a business strategy perspective, right? Not just a legal one, but from your business perspective. Why are you doing it? How are you going to use it? And make sure you're writing it in such a way that it gives that value of your point of difference in the marketplace, not just filing out of fear.
Yeah. And, you know, my favorite tip, particularly when you're writing a provisional patent application, in protecting yourself and kind of breaking it down so you're like, I can do that, is not the legal speak of writing the provisional patent. It's going, okay, here's my widget. And the problem is, the longer you think about your widget, if this is your widget, you go, this is what it is, this is what it is, this is what it is. But when it comes time to file your provisional, you need to think about what else could be. What's another version is 75% good is good, just as good, but not the version that you're going to be pitching. And then that's just being an inventor. All you guys can do that. And so if you create and include those other versions in your provisional patent, that's when you have a strong patent. And I think a lot of patent attorneys would say, the good ones would say, oh yeah, I expect the inventor to do that. The problem is a lot of inventors don't do that. And then a lot of patent attorneys don't force the inventor to do it. And then you have garbage patents that are just covering something very limited and it's not broad in scope. Now, people can get too obsessed with that. You don't want to include a version that's half as good. Then you're getting obsessed. You know, it's not competition anymore.
Well, you know what's interesting about that, Andrew? Someone had, when he filled out that survey, said, why doesn't the USPTO put best practices? You know, I thought that was really interesting. And I have noticed that in other governments, some of their, they look at this a little bit differently. They do have best practices. And I think that's missing. That's a question I have with the USPTO. You're giving us the tools, but why don't you provide some information on what to do with the tools? Okay, sure. I think that's somewhat missing, but I do want to say one thing, Madeleine. Celeste is all the way from, she's on today. She's from South Africa. She runs a great group there. She told me last night that they do have a PPA in South Africa because they copied the USPTO. So Celeste, thank you very much for clarifying that.
Yes, she just wrote a comment, which I also appreciate. Thank you, Celeste. I'll be sure to shout out South Africa. We have just a few minutes here before we expect the director to join us. And Steve, my question to you would be, under what circumstances would you feel comfortable sharing your PPA with a potential licensee?
You know, that's a really good question, because I think everybody says, well, gee, you know, I better have them sign an NDA, and what do I do? When do I show it? And all this type of things. I think what you do, you file a very good provisional patent application, be very confident that you put workarounds and variations of manufacturing and materials, make it look great. Then you file it. You reach out to a company, here's your best protection, that does want to work with you. There it is, you guys, best protection. They work with inventors, they've got a good track record, and then ask them about their process, right? And then once you pitch your idea, and they start to ask for intellectual property questions, or they start to ask for confidential information, that's when you might say, look, this is really great. I know you want to share with me. I want to share with you. So maybe we could sign an NDA. Great time to do that, because it does help you with the non-disclosure issue. So there could be a timing there, but I love to show my PPA. I love it. If I've done it well, it gives them confidence. I know what I'm doing. That's why to include enough stuff in there to give it value, it's a position of strength. Right. So I like to do it, but I don't do it right away. I don't sit on my patent application. There's a timing element to it. Mm-hmm. When I want to share and they want to share, and we start to talk, we start to ask them, you know, your interest level, and I understand that they're inventor friendly, that's when I might share it. Right. So you're hooking them enough to have them express interest, to be asking you for something. It's not out of the blue. I think most people would balk at just being asked to sign a random NDA when they have no context or no interest in the product yet. And so it's not whether you need one, but it's a matter of when. And then it sounds like to me, like you're using your PPA, the way you've written it, to establish credibility, to make yourself seem like the type of person they would want to partner with, you know, which is what a licensing deal is. So it's really not even so much about the issuing of the patent, it's developing this perception, which is accurate because you've done the work, that you're someone that they want to work with, definitely not someone they want to work around. I'm glad you mentioned that, because the way, if you write it this way, not only are you protecting the invention, you're protecting the innovation, you're showing them, you're looking at it from a business perspective, because it's going to get you a licensing deal. But when you do it that way, there's a very good chance there's some intellectual property in there for you to get a patent. There you go. It has all of it if you do it that way. Nice. And I just want to sneak in one last tip here, which is that something I've heard from people like
Jean Quinn, the founder of IP Watchdog, who has a bunch of resources about provisional patent applications on that site. I would encourage you to check them out. He is a big fan of including a lot of drawings, as are we. Sometimes I hear from attorneys, oh, a PPA, the inventor just puts in a few sketches and thinks that that's enough. The opportunity to include drawings is really massive, because if you capture something in a drawing that you didn't actually write about, you can still include it in your non-provisional patent application. So if you are thinking, what's something I do want to spend more money on, maybe that's line drawings and making them, really robust.
That's a great tip, Madeleine. I'll expand on that a little bit too. When you do patent drawings for a full utility patent, it needs to be done just a certain way. It has to be a patent illustrator that does that. But for a PPA, you could pay somebody, or you can do it yourself, and you can make it almost look like a patent drawing, but it's not. And you could just find an illustrator and say, I need some really clean line drawings that kind of look like a patent. So going back to Stephen's point, when the marketing guy sees it, they're not looking at patents all day long. They look at it and they're like, this looks very nice, and so that's a great tip that Stephen's been giving for a long time. So there's a lot of tricks you can use to file PPAs on your own and do a good job of it. Not all inventors do a good job of it, but that's one tip that's going to make you look more pro.
Great tip.
I don't see Kathi in here yet.
Can you find her, Courtney? I'm going to ask you real quick. When she jumps in, can you find her? Okay, very good. I want to talk a little bit about the drawings for a minute, because to me, that's the best tip ever. And I'll tell you why. And Madeleine said this: if you miss something, but you have a drawing of it, there's a very good chance you're covered. A drawing is worth 1,000 words. But let me tell you what else a drawing does. When you start to put drawings of workarounds and variations, it really shows that you really have done your homework. So when that marketing manager sees it, he doesn't really know what he's looking at, right? And then when you add everything else to your PPA, not only have you thought about the manufacturing a little bit, the materials a little bit, how to do it, and then you've added all the other stuff, you're going to confuse it. And no one's going to know if it's going to issue or not. But what you've done, you created this value, you created perceived ownership. And that's why it's so important to do it that way.
Another amazing thing, a lot of you may already know this, but when you file a provisional patent application and let's say you're licensing it and you send a marketing piece and it says patent pending at the bottom, not huge at the top. Don't do that. It makes you look paranoid, but small at the bottom. You don't have to say provisional patent pending. Legally, you can say patent pending. So for $75, you can legally say patent pending. That creates what Stephen's been calling for years, perceived protection, right? Because if you don't later file a utility, you don't get protection from that date. Maddie, did you want to say something?
Yes, I am so excited to share that Director Vidal has joined us. It is a great honor for me to introduce her. She began leading the United States Patent and Trademark Office this April. Before then, the USPTO had been without an official director for over a year. Since she was put in charge, she has been remarkably active, working extremely hard to restore certainty to the patent system and making good on her promise to be as transparent as possible. I've been listening to many of Director Vidal's speeches and have noticed how often she emphasizes the importance of bringing innovation to impact. She understands that inventors not only want to protect their inventions, they want to share their creativity with the world and be rewarded for it. Her background is so remarkable and says so much about her character as a person that I want to spend a few minutes telling you about her before we begin our interview. Director Vidal grew up in a military family and spent her childhood on bases in the US, Panama, Germany, and the Azorian Islands in Portugal. She learned the value of hard work, financial security, and education from her parents, who often held multiple jobs and attended classes at night and on the weekends to earn their bachelor's and master's degrees. Her interest in science led her to attend Binghamton University at the age of 16, where she majored in electrical engineering. Before graduating, she started her career at General Electric Aerospace, later Lockheed Martin. She was selected into the Edison Engineering program and pursued her master's in electrical engineering in Syracuse University's Knight program. During her time at GE, she designed one of the first artificial intelligence systems for aircraft, as well as aircraft and engine control systems that continue to keep our military safe today. Recognizing the value of innovation, Director Vidal pursued a career in intellectual property. She put herself through law school and obtained a JD from the University of Pennsylvania, where she was editor-in-chief of the Law Review. After clerking for the U.S. Court of Appeals for the Federal Circuit, she joined Fish and Richardson PC, where she led a litigation group of 270 attorneys in 11 global offices. She has represented new innovators and startup companies with limited resources, as well as many of our country's most successful and well-known companies. Courtney, will you do me a favor and bring up the slides, please? While Courtney is doing that, Director Vidal, I'd like to tell you just a little bit about Inventor Groups of America. It was co-founded by inventor Stephen Key and former Inventor Group leader Andrew Krauss in 2017 to strengthen the inventing community by bringing its leaders together. Inventor Group leaders across the country work tirelessly to provide their members with helpful resources, educational opportunities, and a safe gathering space to inspire and cheer each other on. IGA has been meeting regularly with these leaders so they can share best practices and learn from one another. We also began hosting a monthly meeting for all inventors. Since then, we've grown into the largest inventor group online. We're proud to have inventor group leaders like Joe Finkler, Don Skaggs, George Burkhart, Celeste Mulland, all the way from South Africa, and Leo York here with us today. While independent inventors represent less than 5% of all patents filed every year, the USPTO is doing an incredible job of outreach and education. So Courtney, if you'll hit the next slide, please. Like I mentioned, Director Vidal has been incredibly busy. Next slide. Just within the last week, we learned that the USPTO had become a WIPO green partner, which means that applications for green technologies will be reviewed more quickly. Next slide, please. She also had the honor of signing an agreement to become the first country to support WIPO and its ability to resolve standard essential patent disputes. Like she says, to support the protection of IP, competition, and economic prosperity, we must support the entire ecosystem and have sound policies. Next slide. Here she is at the Global Women's Innovation Network at the Embassy of Canada at WIPO. Next slide. She's cheering on inventors at the Midwest Regional Office, as well as the Silicon Valley Regional Office. Next slide. She's at Camp Invention from the National Inventors Hall of Fame. She's been to the Federal Circuit Bar Association Conference. Next slide. And as you'll see listed here, these are just like a few of the things she's been doing. She's been so out and about. It's absolutely remarkable. Next slide. In an effort to increase transparency and limit uncertainty, she's already made numerous requests for comment related to PTAB and subject matter eligibility. She's published new reports and guidelines. Next slide. But before we get our interview underway, if you'll bear with me for just another quick second, I want to review, like we promised we would, just some of the many resources the USPTO offers you, inventors and entrepreneurs. Next slide. So if you haven't spent any time on the USPTO's website lately, you're making a huge mistake. There's an absolutely laudable amount of information to learn about IP, to get inspired. Here's just a sample of what the Learning and Resources page looks like. Next slide. You can click on your state by state to see specifically what resources are available to you locally. As you'll see listed, get free patent and trademark legal assistance, learn how to search for your inventions, attend workshops, and there are regional offices all over the country. So no matter what time of day it is, and if it's office hours and you need to make a call, you can connect with someone at the USPTO. Next slide, please. I cannot forget to mention that Invention Con is coming up very quickly, August 10th through 12th. This is a must attend for all inventors and entrepreneurs. It happens every year. It's chock full of value. Stephen has had the honor of speaking there before. I'm excited to tune in. Next slide, please. And something that has just totally blown me away is since the pandemic began, the USPTO has really stepped up its virtual programming. This is less than a month's worth of events here. And the print is so tiny because they are doing so much. So if you feel like you have questions, if you have concerns, the USPTO wants to hear from you, and they are doing everything they can to reach you. So now that I've taken up a little bit of our time, I'd love to hop right into our questions. Director, if that's all right with you. We're so happy to have you here. Thank you for joining us.
Thank you. I appreciate you having me here. And I have to say that as I've gone around the country and talked to inventor groups, one of the main things they say has helped them is groups like this. So individual inventors said that without this kind of support, it's very difficult to get access to resources and keep going. So thank you for all you do.
That's wonderful to hear. We appreciate that. First, we're curious, what have you learned during your first months as director speaking to so many different stakeholders and users of the patent system?
You know, it's interesting because it's, you know, sometimes it's very small things that we can improve and sometimes it's big things, but there's just such an opportunity to make change and real positive impact that that I'm very excited about that. And, you know, obviously there are some people who are a little frustrated with aspects of the system, but there are so many people, whether they're frustrated or not, who just come with such great ideas. And as I've told people, I don't care where the idea comes from. You know, you can send it to me privately. It can be in a meeting like this. It can, no matter where it comes from. If it's a good idea, we're going to pursue it. So we just have so many lines that we're pursuing right now that I'm excited about, you know, making even more change.
That's great to hear, and your actions completely reflect that. You've mentioned the importance of transparency numerous times in your speeches, and you're living up to that through your actions. Will you expand on why it's important to have transparency in the patent system? And is this a personal value of yours as well?
So starting with the last question, it is a personal value of mine that I believe people need to know where you're coming from, et cetera. And I believe in transparency. Even if you hear me speak, I'm very open about everything that we're doing, not just because I think it's important to stakeholders, but that's my approach to things generally. In terms of stakeholders, though, to me, it's critically important because the more transparent we are, the more everybody has equal access to everything we do. So, you know, when I was an outsider to the system where I litigated cases, I always wanted to know the judge and the judge's proclivities, et cetera. And, you know, those people who didn't have that, spend that time or weren't part of bar associations or creating, you know, creating rules with the court, they didn't necessarily have the same access because they weren't as involved. And so to me, the more transparent and open we can be, the more equitable everything we do is, and then nobody has to guess. And so it's equitable that whether you're the smallest inventor, you can just go to our website and find everything out. You don't have to go to big expensive bar events to discover how to interpret things. So I think it definitely helps in that regard. And then in the same respect, you know the outcomes, so it's not inefficient, right? I'm all about inefficiencies as well. So when you don't know how something works, it's really inefficient because you have to try and figure it out. And then if you don't get it right, you've got to redo it. So I just want everything to be as clean, clear, and predictable as possible.
I love that. Transparency is a way of leveling the playing field. That makes so much sense. We'd love to hear what you feel are some of the biggest issues that the Patent Office is tackling today under your leadership.
So that's great. So, you know, obviously they're the ones that get a lot of attention, but I'll tell you the way I look at it. So first of all, I don't see this as something where we're balancing stakeholder interests. I know that that's something that was discussed before, you know, in the past, that there was always a thought about you need to have balance. And to me, balance presumes a zero-sum game. And so what I'm trying to do is figure out how to create the best system possible that everybody can benefit from that will necessarily be equitable. So for example, I want to make sure that when we issue patents and we apply criteria to issue patents, it's the same criteria we're applying at the PTAB. So 101 guidance worked really well in that regard. Obviously that does not apply to IPRs, but it did apply in the past to CBMs, to covered business methods. It doesn't apply to some of the current PTAB challenges. So we're also looking into guidance around 112 and around what, and so just so everybody knows, I don't know who all the audience is, but 112 is basically, are the claims supported by the specification? Is it clear what you invented? Is your invention enabled? So making sure the rules around that are clear, and that it's the same rules both during prosecution when you're getting your patent, as if your patent is challenged later. So the courts, it's hard for the courts to offer that, in part because the federal circuit, the appellate court, has its own jurisdiction, and the district courts have to interpret that. But on our end, we can be clearer because we can issue guidance to say, here's how we interpret the law, and this is what we want you to apply, so that every judge doesn't need to interpret it for themselves. So we're looking at that not only for the specification and how it supports the claims, but also for obviousness, because there's different case law out there on obviousness. We want to make it very clear how we look at it, and in a way that we believe is the right interpretation to advance innovation.
That makes a lot of sense. Independent inventors, it might surprise some people in the audience to learn, only file about 5% of all patents in the US. Given such a low percentage, I'm curious why we're on the radar of the USPTO to help.
So the low percentage is the opportunity, right? That's the number that needs to shift. So big companies they have the resources and they're doing a good job at this. They didn't used to as much. So I remember 20 years ago, I was working for a company that their competitors had patents and they didn't. So we had to go in and teach all of the engineers, what is a patent? What is the value? What is an invention? Because a lot of times, inventors will think that whatever they created is not an invention, because it's not something magical and big and huge and new. It's just incremental. So there's invention harvesting that goes on in these large companies, and there's a lot of great best practices, and we need to bring that to everyone. We need to make sure that everybody has that type of access. And I will say one of the statistics that gives me a lot of hope that by reaching out there and getting more innovators into the IP ecosystem, it's going to do more for this country than I want to work with big companies too, but that's more at the margins. I feel like the real opportunity is getting out there across the country, getting people's great ideas, giving them access to the ecosystem, and letting them create businesses and jobs and grow GDP. And the one statistic that gives me a lot of hope is we're looking at expanding pro bono services. So for under-resourced inventors, to make sure that they can get access to counsel, because we know that they likely need help to make sure that their patent is strong and that it's written in the right way. When we reach out there and connect with innovators, people with ideas throughout the country, wherever they are, the statistics are dramatically different in terms of demographics. Yes. So you mentioned 5%. So if you look at the number of women on patents, it's not much better. It's somewhere between 12.5 and 13%. When we meet people where they are, that number jumps to 41%. So if you think about that, just the explosive growth when you give people the tools and the capabilities and meet them where they are, give them the tools like some of the ones that you mentioned on the website, let them know where they can get access to free counsel. I think many more people are going to participate in the innovation ecosystem, and the statistics show that is going to drive GDP to over, like if we increase it by the inventors by fourfold, that's going to increase GDP by $1 trillion a year. So this is not only, to me, because I've always believed in equity. I always want to lift and support people. I've always donated my services to small entities because I could, and I was available to help them. Whereas the big companies would pay my salary, so that worked. But I'm about equity, but this is not just equity. This is about lifting everyone and giving them an opportunity to succeed in this country.
I really agree with that. And the statistics from the pro bono programs are just incredible because they really do reflect exactly what you're saying. There's such a greater percentage of women. There's a greater percentage of low income inventors. There's a greater percentage of minorities. It's right there. I also want to add that I've been doing a little interviewing of the younger generation, and I see people really adopting they call themselves inventors much more readily than some of the older inventors who are professionals, have patents. And so I see a bit of a groundswell movement where more people in a diverse group are saying, yeah, that's me. That's what I do. I solve problems. And that feels like it has transformational power to me for not only the IP system, but like you mentioned, our GDP, our success as a country, our success as a planet. Okay.
Yeah, and I'll just add on that. We're doing extensive work K through 12. We need to do more. We need to do more. We need to expand that more broadly, but through the National Inventor Hall of Fame and Camp Invention, we're rolling that out. We do training. If you email education@uspto.gov, you can connect in with how we train teachers to teach innovation in schools. So we need a mindset shift in the country, and we're working to make that happen.
That's wonderful. I have a question that I think a lot of people in the audience they've heard this phrase, they've likely thought it themselves. Are patents only as useful as the patent's owner ability to defend them? And if so, doesn't that make it really hard for independent inventors with limited funds to make use of their patents?
So that's a good question. So I've represented, so first of all, I don't think that that's true. But being able to defend them is very helpful. So first of all, just having the ability to say patent pending is extremely useful when it comes to getting funding and getting supporters to bring your product to market. So that is huge. It's also something that you can use to deter other companies. So whether you do it yourself or whether you find some kind-hearted person who's willing to help you, either through an organization like this or otherwise, a simple letter saying, my client has a patent or that's pending, or I have a patent that's pending, that can go a long way to steering people outside of your space. Now, at some point, it does come to the matter of enforcement. Most all of my matters, actually all of my matters for small inventors, I was able to resolve within a couple months and get the other side to leave the market. And so it doesn't have to be protracted litigation. And then even then, if you do need to engage in protracted litigation, there are a lot of lawyers out there that are willing to do it on contingency now. So I know that a lot of people who've built businesses have been able to get contingency fee lawyers. So is the system perfect? It's not perfect. We are looking at, and this is something I was also working on before I came to the office. I was on the Sedona working group that was trying to come up with efficient ways to litigate lower value patent cases. So if your case is higher value, you can likely get contingency counsel. If somebody's ripped off your patent and they're making a lot of money, somebody will help you out with that. We definitely have a market for that now. That's very readily usable. If you have a lower value patent case where maybe you've started to make products, somebody started ripping you off, but you want to end it more quickly, we're trying to find a way to help you resolve those. So the work that I was doing with the Sedona group is continuing. They're continuing to work on that. We're now doing a study within the USPTO on how we can have that type of resolution process within the USPTO. We're working with the Copyright Office. They have that program now, and it's gotten a lot of traction so far. So in our study, we not only have people that were on my prior working group, we have people from the Copyright Office, we have former judges and others to try and shape that system. So is it perfect right now? No. Would I still go get a patent if I was an independent inventor? Absolutely. There's still so many benefits of getting one.
We completely agree with you. We see the value in patents as being not exclusively or at all limited to litigation. And it's really great to hear that you know what it's like to be successful and getting someone to back down or change their strategy that didn't involve many years and costly litigation. That's really not a message we're hearing too much in the IP space right now, I would say. Okay, here's a meaty one. We are wondering, in your opinion, why is the USPTO issuing patents whose claims are later found to be invalid at the Patent Trial and Appeal Board? Some inventors have, in our view, rightfully wondered if maybe the fees they paid to the patent office should be returned to them. We'd love to hear your thoughts.
Yes, so happy to share thoughts on that. So first of all, the strength of a patent is really a two-way street. So, and I'll mention a couple things on this. Number one, a lot of the reason why claims are challenged at the PTAB, it's often on art that was not before the patent office. So during prosecution, the applicant, if they're aware of different pieces of prior art, they can bring it to the attention of the USPTO. Right now, sometimes people don't do that because if you later are found to infringe it, you could be held to 3 times the damages. And so I'm also separately seeing if we can solve for that, because we want people to bring the art before the PTO. And then the examiners separately look for that art. So the system is not perfect now, and especially if your patent issued 5 years ago, it's likely that we've got better tools to find that art now. And it's, it may be the case that you were not the first one to come up with the idea, or that it was obvious. So I would say on one side, we are doing a better job and need to do an even better job at finding that art. And we need to rely on the applicant to also disclose and to look for art, which I realize that there's maybe reasons not to, and I fully respect that, but the more art you can put before the USPTO, the stronger your patent is going to be. We are working on AI and other tools for the examiners, including we want to start ranking the prior art so that the examiners don't need to go through all of the references. They can look at the more relevant ones and make sure that they're doing the right analysis in the beginning, and that they're working with the applicant to shape the claims in a way that will be sustained later on. So that is terribly important. One other thing we're considering is pushing that search early so that we can send it to the applicant in the beginning to say, hey, look, we found something really similar to what you're doing. So they might be able to amend the claims right there and say, well, mine's a little bit different. Let me describe it a little bit differently. So we're working hard on that. But part of the reason for invalidation is the fact that more art is sometimes found later. The other thing is that we don't see at the PTAB, which we see in re-exams, is applicants amending their claims. So I'm looking into this to find out, why are they not doing it at the PTAB, and why are they not telling us what their claims mean? So a lot of times the parties don't want to provide the claim construction. They just want to leave it open-ended. If it's open-ended, it's broad. So and that's going to be more likely to be invalidated. So during re-exam, there's a lot of more claim construction. There's a lot more amending of claims. And so right now I'm focused on discretionary denials, but I'm also in parallel looking into that amendment process, and even thinking about issuing some sort of I know a few years ago, I found out we did a Federal Register notice to inventors to say, here's the interplay with re-exam, here's other ways you can get through the process. So I don't know if that fully answers your question. I will say the guidance that we're working on as well, I think will be helpful. So it'll be the same exact guidance in both places.
No, I think that makes a lot of sense. And that's a message we've been trying to share with the inventor community for a long time, is that one of the most valuable things you can do is to teach yourself how to search for prior art, and be doing that early on, and use it as a tool to improve your patent application. It's not something to fear. It can actually be a selling point if you're very familiar with the art, because it allows you to hone in on your point of difference. So that's exciting to hear about those plans.
Let me just, if you don't mind, Madeline, if I can just add one more thing. So I prosecuted patents for a while, and the way I was taught is like, try and get the broadest claims possible. So if you're using a lawyer and they're getting you the broadest claims, that's fine. But if it's challenged, you need to be able to like pull those back a little bit and say, okay, maybe they were a little too broad. Let me pull them back. So that's why the amendment practice is so important, because it's not that you didn't invent something. It's if you worked with others, they may have helped you try and expand it a little bit. And once you see art that you haven't seen before, you just need to constrict them a little bit.
So maybe could you even say like that could be a calculated plan? Like we're going to go for something that's broader, but then we also know we might amend later on if we need to, type of idea.
Well, that's what happens during prosecution, right? So the
Right.
prosecuting attorneys will normally put independent claims that are broad, and during prosecution they may amend to so that they can actually get the claims issued. Right. But what we're not seeing is that happening in the PTAB. So you can amend it during the PTAB process, but in re-exam, which is a similar process as PTAB, it's more streamlined. You don't have the trial and all the discovery, but the same thing is happening. People are treating that like they treat examination, and they're modifying the claims to get around the prior art. In the PTAB, people are treating it much more like a trial. They're not using all the resources that they have at their disposal, which is you can amend it there, just like you can amend it in a re-exam, and just as you can in prosecution to get around the prior art. So I think there's a lot we can do internally, and we're working on that. I'm not relinquishing our own role and responsibility, but I also want to teach people that what they can do as well.
That's a great tip. Thank you for sharing that. That's interesting. I have, if it's all right, we're getting close to the hour, but I do have one more question on my list, which is that some say that big tech has successfully sought to weaken and undermine our patent system over the last 2 decades. What are your thoughts on that idea?
So I don't really look back at who's doing what. I'm really focused on what does this, no matter who did what in the past and how the laws got shaped, they are what they are right now. And the only way I can figure out if they're working is to go out and talk to people. And that's why I've done so many listening sessions. We've got somebody on the PPAC who's an independent inventor. We've done a lot of listening sessions with independent inventors. I'm open to more. And I am especially paying attention because I know a lot of the big tech positions because they have a broader platform. So I spend even more time with the comments that are received by smaller inventors, by groups like IEEE or some of the other groups that represent small to medium-sized enterprises and inventors to make sure I'm hearing all the perspectives. It's also that big companies often have similar perspectives. And what I learned is inventors have a myriad of perspectives. And so whatever happened in the past, the system shaped the way it is. Like for example, the PTAB, it's been a while. We know that it has had some unintended consequences. It's had some intended consequences. It's time to relook at it and think about the way we can evolve it so that it does work for everyone and take into consideration everyone's perspectives.
I really love that attitude personally. There's a lot of time and effort being put forth into playing blame games, it feels like to me, in the patent system, which ultimately doesn't get us closer to a resolution or an improvement. I
hope people, Madeleine, if you don't mind. So I hope people realize that I think people have gotten frustrated, and I can't speak to the past, but we're working really hard and we want to hear from people and we want to solve the problem. So if people want to do other efforts and have concerns, people can do what they want to do. But if we're going to move things forward, I need good ideas, and I need people to, I'm giving opportunities on everything we do for the public to speak up and express their thoughts on it. So that to me is the most helpful thing for us really reshaping the system.
Wonderful. I mean, what could be better to a group of inventors to hear that you don't care where a good idea comes from? I mean, that's the best thing to hear of all. That's it for me. I know we're getting close to the hour here, and if you have to go, we completely understand. I do know that Courtney,
I do not have to go, so I'm happy to stay. No.
Okay, yay. Wonderful. Courtney, if you could pull up the slides again for us. We did send over, we heard that you were hoping to hear directly from independent inventors, and we did survey our audience and had sent over earlier a Google document spreadsheet for you, so you can see their responses in full and read them. I think there are over 50, and like you said, there are a myriad of perspectives. Certainly, we did pull out some of the suggestions that people said that we thought to present to you in a slightly condensed format. And Steve and Andrew, if you would like to speak to these, take it away.
Well, thank you very much. And I'd like to thank the director for coming on and having a very fresh outlook. Thank you, thank you, thank you. I think some of the frustration I've even had, and I think other people have, is that we just want the system to be the best it can be. So this survey was really interesting because some of the things that people wrote, I kind of feel the same way too. So maybe you could help with it. And maybe there's no answers to it, but Joseph had asked, when you file your non-provisional patent application, it seems to go in a black hole and you just don't know what's really happening. Sometimes it moves through the system a little quicker, but sometimes it doesn't. So Joseph would like to have some type of projected, some type of way to see what's happening in there. Where is it? When are you going to reach out to me and tell me, hey, we're going to look at it next month, or we're going to look at it in 30 days. Or, hey, you better wait another 6 months because we're backlogged. I thought that was kind of interesting.
Yeah, no, that's very interesting. Let me tell you what we're working on, and so a lot of these I will take back because I may not have the answer right now, but I'll tell you 2 things that we're working on. One, we're working on a program, and I don't believe it's been released yet, although I do think I signed it, where I may have signed it, where we're going to offer expedited examination for first-time filer micro entities at no charge to the applicant.
Wow.
So that should help individuals who are filing their first patent application. So just FYI, that I hope will be helpful. The other and hopefully incentivize more people to participate in the system.
Yeah.
The other thing we're going to try and do, and we may actually pilot this first, or we may not, we're looking into this, is we may try and do extra communication. So instead of just getting a filing receipt, you would get more information with that. So maybe it's a cover letter, maybe it's more information in the filing receipt, acknowledging what it means that you filed the patent, that you can now use patent pending, that directing you to websites talking about what the next steps are and the timing and what that looks like. So I don't know how much we can give on the timing and if we can track by application, but I'm open to considering any ideas and taking them back and talking to the patents group and the union about that. So we are trying to help independent inventors more by stepping them through, including as they go. So when you get that rejection, we know that women often will not persist as much as men. That's a big discrepancy there. And I'm sure there's a big discrepancy based on just individual, each individual has a different way that they deal with the rejection. And so we want it to work for everyone. So we like to, again, put some sort of a cover letter with that, saying this is an opportunity for you to, it's not adversarial, it's an opportunity for you to engage with the examiner and try and figure out if there's something there that can be patented. Here's the next steps, and encouraging people to move forward. So, we're developing a lot of content around that and trying to figure out how to make that work.
You know what I really love that you said about the rejection letters, because when the office action comes back, if you're not familiar with that, I mean, you think the world's coming to an end. They don't want me to have a patent. What do I do? It's been rejected. And you realize that's part of the process. So I'm really glad that you're saying that, because some people would probably give up a little early, and you don't have to.
That's right. And just so you know, for the first time, for the expedited program, in order to engage in that program, we're going to require you to do a class online. And that's going to explain the process. So it's going to explain that it's going to take a while to hear back. So don't give up. It doesn't mean that somehow your application is that anybody's made any judgment on it. And then when you do hear back, this is the first thing you're going to hear, but this is really what it means. And it's not a stop sign. It's just an opportunity to engage.
Jasper had asked, and this is kind of, we get this all the time. Andrew Krause, the co-founder as well. Filing a PPA for some people, Courtney said earlier on, it was really easy for her, but for some people, it's a little complicated. I've heard that before off and on. I guess it depends on how comfortable you are with filing things online and making sure it's done correctly. But I think that's something that a lot of people have mentioned to me. And the other thing is patent searching. I know that a lot of people do Google patents because it's a little faster, a little easier. I've been told do that first, then go to the USPTO to do a deeper search. That makes perfect sense. But the patent searching, Ray wants it to be faster and easier. What do you think about that?
So first of all, I am going to take the PPA comment back. On faster and easier, we've now, I think it's in the last month or so, we've given everybody in the public access to some of the same tools we use at the USPTO. So I don't know if that was pre us doing that or after us. I don't know where that comment came in, but we are working hard to say, look, if we have these tools, we want you to have them as well. And so I will take that comment back just to see if there's something about the new system that's out there that that we can improve upon.
I had a question in the chat that I thought was interesting about what is the USPTO doing to audit patent attorneys, because a lot of attorneys aren't doing right by the inventor. And I've found over the last 22 years of coaching and mentoring inventors that a lot of inventors aren't aware of their rights. They aren't aware that you can report a patent attorney to the patent office, and patent attorneys are terrified of that. So Can you go into a little bit about, the inventors' rights, and if they don't feel like a patent, they should always try to make it right with the attorney first, of course. But if that's not working, what are their rights?
So That's a really good point, and there is an office within the PTO that looks into those things and investigates them. So now that you mention it, we should probably put that information. So we now have an inclusive innovation webpage where it's one landing spot, and I have a QR code now on the back of a little business card that I hand out to inventors so they can immediately connect into that. We give them toolkits for trademarks, patents, copyrights as well, even though that's a different area. We want them to know, here's all the IP rights that you can protect. And we do try and connect them in with pro bono, et cetera. But we want to offer more around that. So that's not something I had thought of before, but maybe we need to say, have a concern with a patent, here's where to go. We also, by the way, yeah, go ahead.
Patent attorneys are going to hate me for saying this. I just had a random thought. If every patent attorney or agent was obligated to give a document to the inventor about their rights as an inventor, that would be really cool. I never had that thought before. Maybe that's going too far. Now all these patent attorneys are going to hate me, but.
Well, you know what? That's a really good point. And whether they give it or whether we provide it on the website, if you have thoughts on what you think should go in that, definitely let me know. So I now have an Engage the Director webpage. I thought it had an email on it, but I asked a group, and I'm not sure it does. I think it takes you to web pages that have emails where you can email me. But I just want a general one. If you have just some idea like that doesn't fall within your thoughts on patent eligibility or your thoughts on the PTAB. So I'm going to ask them to put that on there. But I would love to know what you think from an inventor's perspective should go on that kind of Bill of Rights for for patent applicants, because we could get it out there. But I do think directing them in the right direction, including reminding them we have an ombudsman's office that you can write to, and they can help you out with these kinds of things. And so just want to make sure that we're providing all of the resources to inventors.
So it was ask the director. So if they Google, or how do they find that page? That's a great thing. That's fantastic.
So engage with the director. So
engage with the director.
If you go to a search tool and you type in engage with the director USPTO, it'll come. Oh, there you go.
Nice.
You have to say search tool because you couldn't say the name.
Not promoting any company.
You have to. Yeah, that was funny. I just picked up on that. I was a little slow.
Director,
I don't know if there's an email now, but there will be an email on that's a general email. And I'm going to get a summary. I've asked for a summary every week of everything that comes in so that I can on the weekend go through it and pick out good ideas that I want to raise the next week.
Wow. Okay.
Nice.
Very cool.
Would you recommend, is that your preferred way to hear from inventors? You've made it seem very easy for us to get in touch with you, but if there's a preferred way, we'd like to make it easy for you as well.
So it's easy for me, especially if a group like this can consolidate comments but if some inventor thinks, okay, I don't agree with the group's comments, I have my own, I want to hear everybody's ideas. So that's completely okay as well. But obviously, if everybody writes individually, it's going to take me a lot more time to get through it. That leaves less time for implementing. So if you do something consolidated, I've asked the team to find a way that, well, if it's an email, then you can just upload a document. I want to make sure you can upload documents as well, whether it's, here's my red line versions to this portion of the MPEP. Like, is it more specific you are, or here's my draft of the Bill of Rights, and this is what I would say. Like, the more specific you are, the clearer it is for me to understand exactly what you think is going to help.
Nice. That's great advice. Complaints are not as helpful as suggestions
Solutions.
and actions to implement solutions.
I will take complaints back too, but they are not as helpful as solutions.
Totally.
I'll take it all, but
the inventors don't have any solutions for anything. I don't know what you're talking about. Of course they're gonna have great solutions. I'm sure they will.
Nice. Well, Director, if there's anything else you'd like to share with us, we're all ears, but we just enormously appreciate you making the time in your schedule to hear directly from you and your frankness. And I think this is a really exciting time for the inventor community because your actions align so closely with your stated intent. You're really making yourself available. And I hope everyone here, we're so happy to facilitate this interaction, but you heard from the director, she really wants to hear from you. And I just can't thank you enough from all of us at Inventor Groups of America.
Yeah, that would be great. And like I said, I would love even more input because I've represented small inventors, but not everybody. So the more input you have, the better. And the more you can share the word that the patent system works. A lot of the data out there is misleading. Not that we're not getting better. I'm not trying to say it's perfect now. It's not. We're working on that, but a lot of the data out there, people want to make change. So the invalidation rates are, I mean, right now it's only 6% that anybody would lose a patent. And it's, I think only 13 IPRs were reviewed last year where it was an independent inventor or a small company. So the numbers are very, very low. It does not mean that we aren't working across the board to make things better. But if people don't file, then they lose so much in terms of their ability to get funding, to bring their products to market, to create jobs, to defend against other countries that are shipping in counterfeit goods. I mean, there's to do takedown notices. That doesn't cost a lot of money. You know, you had mentioned earlier about patent litigation and defending. You can do a takedown notice. I mean, there's so many things that are available to inventors that they just, you know, get their rights established.
I just want to say, such a fresh outlook. Thank you so much. And we had a great group today. I think we had about over 170 people attending from all over the world. You're having an impact, not just here in the United States, but I know globally now. Courtney, I know you like to do something really special here.
Yeah, we want you to hear everybody here. So Courtney, tell them what we're going to do. I think you probably want to go into a gallery view first.
Absolutely, yes. I'm going to go ahead and remove all of these spotlights and everyone can get ready and go ahead and be ready to be unmuted. Let's go ahead and give it up for a quick 10-second round of applause for the director.
It's going to be crazy. Here we go.
Thank you.
Thank you
very much.
Thank you so much. Appreciate it.
Thank you very much. That was very good.
Awesome. Well, thank you. I look forward to hearing from you again soon.
All right.
Okay.
That was cool.
Courtney. That was awesome. And
Thanks so much. I look forward to hearing from you again soon.
One last thing. We
got another tradition. We want to capture all the screens. So if everybody could give a thumbs up or a wave, I'm going to capture a screen at a time. So go for it. Give a thumbs up or a wave. There we go. Screen number 1. We got 7 screens to do here. Screen number 2. Keep those thumbs up. Or screen number 3. Okay, getting on these other screens. People aren't on camera, so we're good. We're good. Got it.
Well, have a good evening and look forward to hearing from you soon.
thank you so much. Good night, everybody.
Thank you, everybody.
Have a
Thank
good
you,
night.
Courtney.
Bye.
Thank you, Madeleine. Thank you, Andrew.